All right, good evening. I'd like to call the meeting to order. From roll call. David,
Here.
Mark,
Present.
Brett is absent. Jen,
Here.
Greg, absent. Nancy, absent. Brian.
Here.
Clerk Lisa, I'm here. Deputy Clerk Erica. Here. Attorney Mark, Attorney Dan.
I'm damned tonight.
Mark is absent. Dan's here, so we got pizza.
So I'd like to make someone's a motion to appoint a temporary chair.
I'll make
a motion.
Second.
All
Oh,
in
maybe
all-
I motion appointing Jennifer as a temporary chair.
Nailed it. Second.
I second.
All in favor?
I
Nailed it.
don't know if I can vote on me, but all right. So now we need to consideration of the minutes, discussion and possible approval of the October 27th planning and zoning minutes. I need discussion on those.
Motion approved?
Can I say that?
Yes.
Motion to approve?
Ask for one. Yeah.
Can I have a motion to approve?
Do them all, I motion
Yeah.
to approve the minutes.
I second.
All in favor? Aye. All right, any discussion on the November 24th, 2025 Planning and Zoning Commission meeting minutes? Can I have a motion to approve?
Motion to approve the minutes.
I second.
All in favor? Aye, all right, new business. Building code appeal hearing, applicant Sunrise Communities on behalf of SCI Rolling Meadows LLC. The property is Rolling Meadows Manufactured Home Communities. So this is the discussion and possible approval of written decision to affirm or reverse building official decision.
Yes.
That was a lot of words. Okay,
Happy to do the introduction, Chair.
thank you.
Dan Bolin, I'm the attorney for the village tonight. I previously submitted a memo to all of you. As you all know, the building official issued an interpretation related to the development of new manufactured homes proposed by Sunrise Communities. They are the applicant. They are appealing the building official's interpretation to the Building Code Board of Appeals. The Planning and Zoning Commission in the village serves as the Building Code Board of Appeals. I appreciate you all may not have served in that role before. I'm here to help you through it. I'll leave it to the parties to summarize their positions with respect to the appeal, but just so you know, most building codes have a board of appeals, and you're serving that role for the village. Appeals based on the building code are based on a claim that the true intent of the building code or the rules legally adopted thereunder have been incorrectly interpreted. That sounds like what we're here to talk about tonight. Or the provisions of the building code do not fully apply. That also may come up tonight. Or an equivalent or better form of construction is proposed. That is not the subject of this appeal in at least what I've seen. This is important. This is different than the other kinds of applications that you see on the zoning side of things, where you might see application for a variance or variation. That's not what the Board of Appeals on the building code side is here to do. They do not have the authority to waive the requirements of the building code or interpret the administration of the building code or like get into the nuts and bolts of how the building officials doing their job. The village board can get into that should this be further appealed to the village board. But you will be making a final decision tonight if you're ready, and which is different also then in the zoning side where you're making recommendations to the village board for a final decision, your final decision-making body tonight. And should you be ready, we have proposed written decisions for the planning and zoning commission to consider for approval. So your planning and zoning commission already has existing rules that will generally work for this, except for that final decision-making point that I raised. The way that those hearing procedures generally go, we have the introduction by the chair and the summary of the appeal by staff. The applicant will have an opportunity to make a presentation under the rules. Followed by general public comment. I don't see any, but we do have to allow an opportunity for public comment. And the building official will have an opportunity to present evidence or argument in support of their position. It is a hearing, so cross-examination of witness testimony could be allowed. That just means one side gets asked the other side questions of the other side's witnesses, should they want to. And then it's the applicant's appeal, they get the last word before questions by the planning and zoning commission. The chair will moderate those questions to the appropriate individuals as they arise. And finally, you get to talk amongst yourselves and then make a decision. I recommend that final motion be a motion to affirm the building official's decision, only so we clearly know that yes means we agree with the building official and no means we agree with the applicant. And then once we know the kind of decision the PZC is interested in making, should you be ready to make one tonight, of course, we can prepare a proposed written decision after a brief recess for you to come back and adopt, because I did not print them in advance. But because I wanted to see what happened.
Okay.
So unless there's any questions for me before we get started, or from the applicant or the building official chair, I would suggest you turn things over to the applicant for their presentation. Should anyone be present on behalf of the applicant? I expect there is.
Yes, I am here on behalf of the applicant, and I apologize for just kind of coming in just now. There was a crash on I-90 that
Oh my goodness.
affected traffic.
Well, you made it at 6. So, okay, then I guess we need to swear in.
Yes, if anybody's going to be testifying, that doesn't hurt to swear them in. Of course, if it's just legal argument we're making and we don't feel the need
We
to
don't have to.
sworn, I would just ask if any party's going to testify that you could swear them in all at once.
Is anyone going? How do we know what's testifying, what's legal opinion?
You know, I'm just thinking about like what I would do if usually attorneys aren't testifying. I suppose it doesn't hurt, and I leave it up to the parties to say whether they want their comments to be sworn testimony and up to the record. So I would suggest you ask if anybody wishes to be sworn and plans on testifying tonight. I would ask that they raise their hands and ask to be sworn.
Does anyone plan on testifying? Would they like to be sworn in?
I don't think I've ever had to before one of these.
Oh, we always,
It-
but yeah, no, that's fine. That's fine. We
up to-
we had a lot of testimony the last couple of months, okay?
That's fair. I'll leave it to the parties
Yep.
to police their own presentation. Chair, I think it would be appropriate time to ask the applicant to make their presentation.
Okay, if the applicant would like to. If you mind stating your name.
Yes, good evening, everyone. Blake Stubbs, STUBBS from Newton and Lieberman on behalf of the applicant. My office address is 33 North LaSalle Suite 1150 in Chicago, zip code 60602. And I also want to state for the record, I am not presenting any evidence tonight or anything of that nature. This is purely a legal dispute and not really a factual dispute at all, so I don't think there's any need for that.
Yeah, I'm good.
All right, well, first of all, I want to thank you all for being here tonight. I know that this is a special session of the commission and not a regular session, so on behalf of my client, we appreciate the commission making the time to do this, especially given the timing, the holiday coming up. There's obviously quite a bit at stake here because we're talking about permits for 19 units, which represents not only a significant amount of potential revenue for my client, but obviously also 19 potential families that could be living in the community. So as I said, this is purely a legal dispute over whether the Electric Vehicle Charging Act, which is a very new statute, it's only just it's been enacted within the last coming up on 2 years next week, I believe. So there isn't any body of case law or litigation or anything like that would give a commission like this a frame of reference or resource to look at to see how courts interpret these things. Excuse me. And as I don't know if everyone in this room has read the memo that we submitted after receiving Mr. Boland's memo. We did send in something a few hours ago, but I just want to briefly summarize what we said in that, which is that our position is that the Electric Vehicle Charging Act does not apply to manufactured housing because the definition of single family residence that the statute uses refers to a detached dwelling, which in turn applies or implies that it governs permanent structures, buildings. And the whole thing about manufactured homes that makes it a manufactured home is that it's not a permanent structure. It's movable. Hence why they're often referred to as mobile homes. And so at least by the plain text of the statute, we obviously disagree with Mr. Bowen and the building inspector's interpretation that the statute applies to manufactured homes. Furthermore, I would submit that if the statute was intended to apply to manufactured homes, it would say so. It does not. The only provision in the entire statute that even mentions manufactured housing is to draw a distinction in terms of what are known as tiny homes. And again, the statute defines the phrase tiny home with the word detached, which again implies a permanent immovable structure rather than something like a mobile home. I would also note that there are other statutes such as the Mobile Home Landlord and Tenant Rights Act and things of that nature that employ a very detailed definition of manufactured homes. I think if the legislature intended for the Electric Vehicle Charging Act to cover manufactured homes, then they would have not only said so, but also would have inserted that same detailed, precise definition of what a manufactured home is that appears in so many other statutes that govern manufactured homes. Excuse me. The last thing I'll say, and if you'll permit me just a moment, please, to look over my notes. The last thing I'll say also is that manufactured homes are not subject to real estate taxation under the property tax code, which again implies a distinction between manufactured homes and a single family residence within the meaning of the Electric Vehicle Charging Act. So for all of those reasons, our position is that the permit should not be denied, that they should be allowed, because this type of property just was never meant to be part of the Electric Vehicle Charging Act. It was never meant to have that requirement attached to it. I'm happy to answer any questions you may have.
The 19 homes that are mentioned, if they need the EV charging, are those 19 not going to be built? Like that's the line in the sand.
My client estimates that it can, if necessary, refurbish these units to accommodate that requirement if this process shook out that way. Although I would note that it would be at substantial cost. We would be talking tens of thousands, maybe upwards of $100,000.
So I think they sent us also, I guess their covenants. Where you have specific rules in there that if they want. They will let you build these things without the EV charging, but it says that if somebody moves in there and they want one. They're allowed to do it based on the documents for the development.
What are you referring to? Are you referring to the lease?
I think it was the leak, sorry, we got like all these papers.
Yeah, a lot of papers.
Yeah, I think there was a lease agreement in there just saying that they can install it, but they just have to have insurance. So basically what I'm saying is. If you go ahead and put these in without the chargers and then somebody comes in and buys an EV. By the way, there's only like 100 in Ogle County. They can install themselves and the development won't keep them from putting it in, just like that, if I wanted to put it in my house.
But it would be at the renter's expense and it
Yeah,
would,
exactly.
and they're renting a property that would benefit from them having built an EV charger on it.
Well, that's their choice. Or get out of.
Yeah.
Okay.
Few points I want to follow up on. Just responding to the applicant's presentation, you referred to the Mr. Boland's position. I don't have a position here. I'm here to represent the Planning and Zoning Commission and facilitate a fair hearing. And the memo that I sent to the Planning and Zoning Commission just summarizes the parties' positions as I understand them. The act itself does not require the installation of EV chargers. It just requires the installation of the infrastructure. I'm sure the building official is going to get into that in their presentation.
Thank you for the clarification on that, by the way. And Mr. May, to your point, I haven't seen the specific leases for this park, but I can speak generally based on my familiarity with how these leases are typically written, that the answer to your question is yes, that the tenant would be able to make the improvement on their unit if they wanted to. I also do want to clarify, just for context and background, that when I say tenant, typically the arrangement in a mobile home park is that someone leases the manufactured home, leases the land that the manufactured home sits on, but owns the actual unit.
I did have a comment on the memorandum. I was looking at the definition here. Manufactured homes are not detached single family residents because they are not permanent. And a manufactured home is a movable and or portable factory solid structure. Part of my job is dealing with definitions of manufactured housing, condominiums, residential structures, as it relates to smoke alarm installation and life safety equipment. Just looking at the Illinois legislation, manufactured homes absolutely not single family residence. That's usually regulated by HUD. And like I say, unless there's something to sway my definition, either in the Illinois requirements, I've never seen a International Building Code, Fire Code, Residential Code, NFPA 101, anything from HUD that says manufactured home systems, detached single family homes. So I think it's fair to say that these requirements do not apply, which is different than what we may wish for them to have in that area.
Thank you. I appreciate that. And to kind of piggyback off of what you just said, actually, the state agency that governs mobile home parks and issues licenses to operate mobile home parks is the Illinois Department of Public Health. It's not any housing agency.
Chair, unless there's any other comment or questions for the applicant, I think you could ask for public comment. I don't see any, but then offer the building official opportunity to make their presentation.
Okay,
Thank you.
if the building official would like to make their statement.
Hi, I'm Sean Fallows with BNF Construction Code Services. That's FALLOWS. We're at 2420 Vantage Drive in Elgin. So I'm the creator of this problem, so that's why I've been sent me. So in the process of doing reviews, we try and make sure we're following both your local statutes as well as state statutes. So while I agree that this statute has some questions and issues with the language from the state, for instance, the detached single family has some language. They were clear and concise about writing out certain items, tiny homes. They would have had an opportunity to either come back or correct that item. They have not. So when I look at the language detached single family residence, I go and say, what is that closest to? A single family residence, a dwelling unit is what we would call in the building codes. For the means of permanence, your local building codes and building code and fire code say anything that's going to be there more than 180 days shall be treated as a permanent building. Additionally, both the building code and the residential code has appendixes, while you may not adopt them because of the state law, that help regulate things like manufactured housing and how to deal with manufactured housing as well. So I think what it comes down to is, do we want to allow for the people that are living there to have the opportunity to have an EV vehicle without significant additional cost? The state law basically just says, make sure you have the infrastructure in place to be able to add an EV charger later. You do not have to put the EV charger in now. It's just the additional capacity at this time. Depending on the specifications, that may be something that they could explore, whether the new units have that capability in and of itself, or modifying the electrical service to provide that before entering into the manufacturing home. I think a lot of our stuff was provided already in our items there, but we just try and present the information as needed. Is there any specifics from that you have questions on?
You brought up some new information. It's a bit of a brain teaser, so if it's there for 180 days, considered permanent, does that turn it into a detached single family residence? I don't know. It could be argued.
So the state and it only tells us detached single family, small and large residential. They don't deal with mixed use. So like if you think of where like in Rockford, you put retail on the first floor and how you do everything on the upper floors, they don't tell you how to deal with that situation. There's a lot of situations they do not tell you how to deal with. We're saying that a detached single family looks like, sounds like a dwelling unit. Whether or not it's going on a permanent foundation and built to the IRC, or permanent foundation or non-permanent foundation, either are spelled out by the Illinois Manufactured Homes statute that you can use a permanent foundation or a non, depending on the installation method.
Is there any precedent for this anywhere else?
We've brought this up now in one or two other communities now. We haven't really, you were our first test case that sort of kicked in as well. We've shared it. We shared it with some of our other clients, because once we realize something, we try and let people know. We're not trying to catch other people off guard. I had a conversation with a village administrator a few weeks ago, and they were already in the camp of, we're just gonna say that they're gonna need EV capable. And that was their position. Now, he doesn't speak for the board. That was just him as the village administrator at the time.
Is there anybody at the state of Illinois that can provide the interpretation?
Unfortunately, there is an EV ready person, but they declined. I did speak to some people at a capital development board, and they couldn't give an official, but they said like, hey, I'm working codes, I'm reading it the same way as you, I can't officially say that. So they didn't provide anything else on that. So we did reach out to a few different agencies and tried to get a few different, we reached out to the SIU, is it Southern? I'm trying to remember their new name. They're basically the Energy Council for the state of Illinois, but they look at a lot of state statutes, energy related items, they've dealt with some things. And they sort of said, okay, this is not our area of expertise, but I'm using it the same way as you are as well. So this was not like a simple decision to come across. We debated it internally, but it came down to that same argument. Do we want to make sure that those people living in that location has the ability to choose to have an EV vehicle without a significant additional cost later on? Those numbers do change a little bit for a manufactured community, a manufactured home community. I will not disagree with that point that it would be more expensive for a manufactured home versus a traditionally built home. But that's where it came from.
Any other questions?
Oh, one last point, I would say just the fact of omission from the state statute doesn't tell me anything about that we should be leaving out that regulation. If they wanted to clearly define it not to include manufactured homes, then they should have included it instead of speaking to it, as they did with tiny homes.
Is there anything else that would force the installation of this, like through HUD?
A lot of the federal statutes are still being worked on. There's been more than one proposal I think floating around for sort of like new manufactured. When you look at the federal level, but they're not moving that fast.
Any other questions?
May I do some cross-examination briefly?
Oh, sure.
Good evening, Mr. Bounds. Forgive me if you said this already, but can you please tell me your job title?
Oh, vice president, sorry.
Vice President, okay. Are you a lawyer?
No.
Do you have a Juris Doctor degree? Do you have any formal training or education in the law?
Well, via the building codes, because they are adopted as a reference statute. That would be the area I have experience in training in.
Sorry, I'm just reviewing my notes here. That's all I have. Thank you.
Chair,
Did we discuss, or do we have to move straight?
the applicant can get the last word to respond to anything. Building official had to say during their presentation.
All right.
Thank you again. So a couple of things I wanted to bring up here. Number one, it seems clear to me that that it's unclear whether the statute applies to manufactured homes. You know, I've said obviously that it doesn't seem to apply because the statute doesn't mention it, other than that one provision that I cited earlier. Mr. Fallows mentioned earlier that his position that the legislature, if they had intended for it not to apply to manufactured homes, that it would have said so. In that situation, a judge reviewing this issue would then go beyond the plain text of the statute and look at the legislative debate around it, which Mr. Bowen provided in the memo that he submitted, and which we also provided in the letter that we sent that formed the basis for this appeal, which is the, I think, crystal clear intent that the legislature did not want this statute to apply to manufactured housing. The other thing I wanted to bring up is the point about the building code providing that a dwelling is permanent if it's intended to be in place for more than 180 days. That's all well and good, but that's not what the issue is here. The issue is not what the building code says. The issue is what the Electric Vehicle Charging Act says. So I would submit that that point really isn't germane to what this commission is being asked to decide. So in conclusion, I think we've shown sufficient legal matter, let's say, for the commission to overturn the building official's decision and to grant these 19 permits. Thank you very much.
Chair, this is the opportunity for the PZC to discuss and deliberate among themselves, first, if they have any members have questions, they can direct those questions to you, and you can refer those questions to the appropriate individuals, be it me, be it the building official, be it the applicant.
Do we have any questions, or do we want to move forward to discussion? Yeah.
So on your case, being the building inspector, are you doing this also to protect your company? Well, so if they decide, oh yeah, you can put them in, but then down the road, the legislator, somebody comes and says, oh no, he didn't have to do that, or he said he didn't have to do it, and then they have, like, they misinterpreted the law. Are we like,
Well, that's, I
you know,
think,
giving them a break? I mean,
I would say that's what our discussion here is to do, is that the law has, the legislation has not clearly omitted or included manufactured homes. So we need to make a decision on how we feel that should be included in our community.
and then once,
No?
and then once the decision made and whatever happens, then if the law changes, and sure it's gonna happen again with all these EV rules and, you know, mobile home parks, there's probably gonna have to go something up the ladder in the court.
Well, I mean,
But
once,
Then that would affect new construction.
that would be new construction after that fact. Like,
Mm.
we're not gonna be able to come back in time
Oh, I'm,
to say this should or should not have been done. Now, maybe we can look back on it historically in the future for other decisions and say, we made a decision to go left, and after a series of time, potentially right would have been the avenue, but that's a future state that we just can't plan for. We need to deal with the now.
Sure, and to your point, Chair, just following up on your questions, the board's role is to consider the appeal. The reason this appeal is before you is the reason it's in the code. The building official has to make countless interpretations part of their day-to-day job. And there's an avenue for applicants to appeal those interpretations, and that's why they're coming before you. It doesn't happen very often. It doesn't usually. The building of they work together and come to a resolution. In this case, the applicant exercised their right to appeal and was looking for your help in interpreting the law. It's not so much the whether or not we like this idea, whether or not we should this is right for our community. That's the General Assembly already decided what the law is. You're applying you're reviewing the building official's interpretation. And you mentioned that about whether the act mentions manufactured homes. It in fact does. And this is in the memo. The statute has the EV Charging Act requirements for the infrastructure for detached single family homes. They adopted an exception for tiny homes. This does not apply to tiny homes. And in making that exception, there's an exception to the exception that a tiny home does not include a manufactured home. So it does talk about manufactured homes. It's the applicant's position that they're distinguishing them. It's the building official's position. No, this means that they would not have had to make an exception to the exception for manufactured homes if the whole law didn't apply to manufactured homes in the first place. So it's a very fine point, but I think that's an important point because that is the text of the statute is the best evidence of the legislature's intent. I'll stop talking and leave it for you to refer to more questions.
I had one question. So we're looking at Illinois compiled statutes. This is affecting what's in this area. Is there anything on the federal, international building code, national building code that contradicts this? Do they have any jurisdiction here, or is it strictly the Illinois statutes we see here?
You want to help us with that?
The current building codes are starting to look at things like this.
Right.
Not in the same way.
Why?
So the easiest example would be for a few cycles now, accessibility requirements for EV charging has already put that in there.
Right.
They're starting to look at things both on the energy side,
Right.
but keep in mind that the book, the 2024 book, was basically being wrapped up 2 years before that. So it's a slower cycle, but I would say that in general, ICC is a little less heavy-handed with certain things. So the 100% for multifamily would not be something I would ever expect ICC to do.
Specifically in Illinois, if I were to Google, they would tell me NFPA 72, whatever year applies, NFPA 70 national code, what year applies. Is this the only thing that applies in Illinois to this area?
Yes.
Okay.
Yeah.
Any other questions, discussion points?
This seems time sensitive. I would almost like to have more time. Unfortunately.
Chair, I mean, it's up to the. I prepared tonight so that the PZC could make a decision tonight if they so wished. If they want if the wish of the commission is to postpone consideration to another date, That's also possible.
What
But
would
keep in
more
mind-
time, like that, what are we gonna learn in a week, in
Is there
a
any
month?
Additional information we may find. What's happening. Any other precedents, any other states.
Cause I don't think another state holds precedence over us, because we could look at Tennessee and they're gonna do things a lot differently than they are California. So, I mean, we can go back and forth all day with blue and red.
But a lot of these people write about the same thing. And see which way the interpretations are going, maybe, but I get your point, it may not.
Yeah, I would like personally, I think. I don't know what, like I said, more time, because I think again, that argue could go tick for tack with.
Yeah.
Cause I would venture a guess that Wyoming and California might be on opposite ends, but who knows? Do we have any other questions? Any other clarifications? Any discussion? We're a quiet group.
No, I just have one more comment.
Yeah,
So I'm looking at ILCS. And it does say this act applies to newly constructed single-family homes and multifamily residential buildings. Maybe Illinois didn't do a very good job of defining these, but these are keywords that are defined in other places,
Mhm.
and I imagine that's why they use them. If you read what it says, it does not include manufactured housing, but very often when it doesn't say what you want it to say, they talk about the intent, right? So,
yeah. Well,
just the way it was.
and for discuss, can I just discuss? Can I just openly make a point?
Yep.
I don't, the whole chair thing is freaking me
Yep.
out now. Cause I guess the way I look at it is this statute, the Illinois legislature felt that this statute was the way our state needed to go, and it was what's best for our residents. I don't see why not upholding the statute would be better for a resident. We're saying the infrastructure needs to be built correctly, because in the future state, this is the way the world is turning. Like, so do we really want these 19 structures to go up and not have the infrastructure to be able to have a vehicle on those properties? This is likely a more an economically different part of our community, and I don't necessarily feel that it would be a fair representation to not uphold statutes for them. I think it's kind of a bit of our responsibility to make sure that they are held up, the statutes are held up there. And to be completely honest, there's enough problems happening for those residents that I don't want to make another decision that would put them behind the eight ball. And that's just kind of where I stand.
Well, we're actually moving away from EVs. So I work in automotive, tier one automotive supplier, and Ford just announced they're canceling the Ford Lightning. GM is slashing all their electric vehicle volumes, basically to nothing. So EVs are going away, whether you like it or not. They're going more towards the hybrid route. So what does that entail? I mean, sure, you got your plug-in hybrids and your auto regen batteries. But I think in 2024, when this was written, everyone was adamant about pushing EVs. Belvedere was going to build a whole battery assembly plant, and that has been axed. And now they're going to bring in the Cherokee back and the Compass, and those are supposed to be ICE vehicles. So all your, especially your big three, are moving away from EVs and going towards the hybrid route. And with that said, in the time when this was written, I think everyone expected EVs to be a lot more. But I don't, in my opinion, I don't think this applies to manufactured homes, just because based on the definitions I've read and heard, that it doesn't, that's not what a mobile home is, in my opinion. That's just my stance.
Yeah, I see Jennifer's point, I just don't know which way it's gonna play out. You'd like to give these people the benefit of doubt of having these fixtures, on the other hand. And what the cost may be, they may have no place to live. Put another 100,000 on it. So I don't know.
Again, it's just for the infrastructure. They don't have to put the charging station up. They have to establish an infrastructure that a charging station could be. And I
Is that That's subsidized by the state, or is that gonna be tacked on to the price of the housing?
And just a reminder, and just zooming out again, that we have a very limited focus as a building code board of appeals. There's policy arguments to be made in support or in opposition to the EV Charging Act. We're not a policy making body here tonight. We're just evaluating whether or not the law applies.
Help, sir. Yes, come back, Dan.
And while you're all thinking and discussing and deliberating, maybe I could suggest a minor bit of housekeeping. I prepared a series of exhibits that were in your packet that were shared with the applicant, shared with the building official. I would just ask, unless there's any objection, that those be admitted into the record and for tonight's hearing.
How do I do that?
Ask if there's any objection.
Is there any objection to entering the exhibits? Do I have to name them all off?
No,
Okay,
exhibits 1 through 7.
exhibits 1 through 7 into the meeting minutes, right? Or meeting, just it,
Into the record for
into the record. Is there any objection to entering exhibits 1 through 7 into the record?
No objection for me.
No, no objections. Okay, so exhibits 1 through 7 will be made part of the record.
Thank you.
I'm gonna bring one more thing up.
Mhm.
I was just kind of reading through this, it's page 5. I don't know, what this. Oh, it was junction. Apparently they pulled out some of the debate during legislation.
Mhm.
As we see this commentary in the hauler, the act does not expand the manufactured homes. Am I reading that right?
Right. Chair.
Yes,
So, just to speak to that, I know that the applicants, spoke to it during their presentation. The building official alluded to it too. The only time that courts will look at legislative history is, when they find that the language of the statute is ambiguous. And the building official's position is that the language of the statute is clear. The it apply a manufactured home is a single detached single family dwelling. The act applies. They even went so far as to say when they were making an exception for tiny homes, that manufactured homes are not exempted, inferring that manufactured homes are subject to this act. But it's the applicant's position that the statute's ambiguous, and when you do look at the floor debates, there is one member that asked if it doesn't apply to manufactured homes, and you see the debate there suggesting that it doesn't apply to manufactured homes. The question is that one comment during floor debates enough to overcome the plain language of the statute?
So could I paraphrase it as saying our elected representatives really didn't settle the topic and weren't sure of themselves?
Yeah, Chair, I think that
Yes.
you know, we see this at the village boards from sometimes. Everybody the village speaks as one voice, and the village board speaks as a collective and not
Mhm.
any individual member. And so, the courts will consider that and looking at legislative history as well. It can be suggest legislative intent, but the best evidence of the intent is the language that everybody voted on and agreed on.
Any other questions? Or discussions?
No, thanks for your patience.
Nothing. So do we, okay, are we moving to a vote or are we moving to look at the,
So I think there's a couple of choices. If the commission's not ready to make a decision and wants to think about it and set it over for another date, somebody could make a motion to postpone consideration to a date that everyone's available. If the planning and zoning commission is ready to make a decision, I would suggest that you make a motion to affirm the building's official's decision. A yes vote means you agree with the building official, a no vote means you agree with the applicant. And depending on the outcome of that motion, we can go prepare a written decision during a brief recess for you to adopt again in open session and share with the parties. But I think the initial question is whether you're not whether the members are ready to make a decision tonight or not.
do we feel we're ready? Or anybody?
Yeah.
Yeah,
Okay.
can I make mine? So I move to affirm the,
I think you ask for, as a chair, you can ask for a motion.
can I get a motion to affirm the building code, what am I calling it?
The building official's decision.
Okay, can I get a motion to approve the building official's decision? I see it.
I see it. Yes, I second your motion.
No, I need you to motion it.
Oh, you can't do that?
No, I can't do that. I know, that's my role here. And
Yeah, the PZC is ready to make decision and I suggest a motion.
no, I suggested the motion. I need you to make the motion.
So
I'm
moving
making the
forward.
motion.
Yes.
You see, we do this all
I'll
second.
second.
Yeah.
All right,
Had a busy year.
so we got a second.
A roll call from the
So an I means
I vote.
we are affirming the building code decision
And you agree with the.
and we agree with the building official.
And no vote means you're reversing the decision and you agree with the applicant. You're welcome to have any final discussion before a vote. If there's no further discussion, you could ask the clerk for a roll call vote.
Any further discussion? Clerk, can you please roll call vote?
David,
No.
Mark,
No.
Bertie is absent, Jen,
Yes.
Greg is absent, Nancy is absent, Brian,
No.
So that motion fails. I would ask for a brief 5-minute recess. Chair, I could prepare a written decision. We can come back and adopt a written decision consistent with the commission's wishes.
Can I just put us in recess?
Um,
Or I asked some motion?
I don't think anybody's gonna object to you just putting us in recess.
All right, I would like to put us in a 5-minute recess while Attorney Dan gets our stuff that he said he was gonna do
Right,
together.
thank you all for your time. Appreciate it. when I do these hearings, these are the highest pressure.
I'm calling back to order, all of us. We'll be in order.
Chair, thank you. We circulated a proposed written decision for the PZC to consider consistent with the direction of your last motion. It's just a draft decision. Any changes, amendments, suggestions, typo corrections are welcome before this is finally adopted. If you're ready to adopt this, I would ask for motion to approve the written decision and just confirming your prior decision in writing, and then if you, as chair for tonight's meeting, would sign it, we could give signed copies to the parties and close out this public hearing and move on with the remainder of our agenda.
Do I have to read this whole thing out?
No, you do
Okay.
not need to read it aloud. That is why I wrote it down in advance. But yeah, but please do take the time to write it. I did not circulate it earlier because I did not know what would happen here tonight. But I did prepare something ready in case you were all ready to make a decision.
If everyone has had a chance, I'm speaking slowly, to review, and someone would like to make a motion to,
Motion to adopt the written decision.
a motion to adopt the written decision?
I'd like to make a motion to adopt the written decision.
I second.
Absent any discussion, the clerk can take the roll.
Any discussion? Clerk, will you please take the roll?
David?
Yes.
Mark?
Yes.
Brett is absent. Jen?
Yes.
Greg is absent. Nancy is absent. Ryan?
Yes.
Chair, that concludes this public hearing. We can move on with the remainder of the agenda.
So is there any unfinished business? Is there any public comment?
Just a clarification on process, now that we have this, there are still open zoning items that need to be addressed for all 19 submittals. Just so that there is no permit to issue at this time, there is still resubmittals for all 19 projects.
That,
Chair, I think that this was pretty plainly focused on.
yes, yeah, that would be,
I know, I just want to make sure that
thank you.
it's on the record that we're not about to go process 19 permits.
No, yes, this was solely based on this one specific component. And that is all that has been,
Well, that the applicant has to go back and correct the other items.
Yes.
And resubmit.
yeah, we have got no insight into what is or is not additionally pending. This was this one piece of business.
Make sure everybody's aware.
And that is the applicant's understanding as well.
Okay.
I just didn't want somebody thinking I'm sending out 19 letters tomorrow. I will update our records so that there will be no confusion. I will be personally marking them all so that there should be no confusion, no matter what comes in and is or not included, it will already be in our records.
Thank you.
Yeah.
Any other public comment? I would ask for a motion to adjourn.
I'm with go. I second motion to adjourn.
No, I need someone to make it.
Adjourn this meeting.
Oh, there you go. Now you can second.
I second.
All in favor?
All in favor? Aye. All right. Thank you. The meeting is adjourned.
Great job.